Thanks, Crystal. And good morning, colleagues. I want to say that in terms of, this is the first time I'm being asked about the question of political. So is it a political party that I affiliate? But let me not go to the Kenyan political formations. I think the only party that I can talk about is the one of Chama ya Baba na Mama in Kenya that is KANU. Because of my mom used to have those stickers. That's the only closest political party I can talk about. But in terms of my political leaning, I'm a social democrat. Social democracy is where I believe that the state has a responsibility and an obligation to better the lives of the ordinary people, and the use of states as an instrument for good. And then in that journey, the participation and the contribution of the public in that process, because there's also a feeling at times that when you do so much for people, you suppress their voices. It's possible to have a balance. That is my leaning. Since we're in PAC, I would be able to say that I am a Pan-African. When I was working for tax justice, we visited Cameroon, and there is this imaginary boundaries that you can actually do your work and the people are the same. I believe in Africa can be a better and can actually do more. So that is on the Pan-African front. And then on a day-to-day basis, a friend, a brother, I think you remember we were with you in youth scenarios. So that's how I introduce myself as a person. I go ahead? Okay, thanks. When you when we were invited to share about this topic, I usually draw a graph of like a quadrant of 4 things. That is policy, process, power, and politics. So if you're drawing the compass and you have north, I will be able to put policy on the north, and then to the south, I will put process. And then to the west, I will put power and politics. In this conversation within the Pan-African platform, I find at times most of our conversation is limited to the policies and processes. Yet, really where the key decisions and the key drivers of interests is in the quadrant of power and politics. Now, coming to the context of the IFFs and looking at the Kenyan example, I would want to say that our issues in Kenya are not policies. We have a very good constitution, we have a very good mining act, and we have the institutions in place. The problem is that in our context, looking at the IFFs, the problem is in the political and the politics space. Let me give my observations that I had when I went to, we are in the process of developing a strategic plan for Haki Madini that made us to then go to Migori together with the FLOSPA. And I want to give the example of IFFs from the perspective of the community. First of all, there are parallels between the interests of the community and the interests of the investors. On one side, you have companies that are politically supported. They have the money, they can hire the best experts to articulate the issues, what they are doing. They will talk about, this is what we have done. But when you summarize and you analyze the perspective of the investors on one side, you realize that their approach is a tokenistic approach. We have educated this number of people, we've built this number of schools, these are the number of scholarships we've given. But this data is not scrutinized. So in terms of one area where we see losses or even IFFs, for example, when they say we've given this number of scholarship, they don't provide this data. And what is available in the books and what is available in what they are saying in public, there is a disconnect between the two. So one of the things that I would want to be able to say based on what I see on the ground is the failure of organization on the part of communities. that then ensures that they are not represented on the table. The other thing, or the political tool that they employ, like I saw in FLOSPA, is that those that are in power, the politicians, the chiefs, the county commissioners, and all that, are already in the pockets of the powers that be, together with companies. So one of the things that they would be able to estimate their costs, cost of investments, cost is the bribery that they bribe the system, so that to facilitate their businesses. And why am I sharing this, Crystal, is because there is a disconnect at times between even what we have in paper, in documents, vis-a-vis what we see on the practice. So I would summarize by saying that if we are able to change the power conversation at the local level, because the problem is not policy, the problem is not institutional, the problem is a power and a political issue and a captive community. In Kwale, for example, the government is responsible for relocation. The millions that have been used for relocation, if you are a DC, that's a district commissioner who is supporting the communities, you get a call from State House and they transfer these people and you're told, why is it that you are not supporting investors? So what we see is that as a result of a captured political system, and a skewed power in favor of the investors, in favor of the companies, and an opaqueness in terms of data and information that is available for scrutiny, what happens? We are not able to see what is it that these miners, these investors are doing. So I would say one of the drivers, therefore, of IFFs is opaqueness, in terms of information that is availed to the public, a disorganized community, and then a power play where divide and rule is able to prosper within their context. I will be making my recommendations towards the end at some point on what civil society, what such platforms can afford to actually change the power dynamics on the ground, policy-wise, implementation-wise, and within the political context. I would just conclude by saying this, because we were allowing time, that when we have this conversation at PAC level, let us always ensure that we complete the narrative between our examination of policy, so the constitution, the laws, the bills, and then the involvement of people through the processes, the ownership, that is processes, but also let us ensure that we have this conversation between the powers and the political conversation within the equation. And how do we change the political equation? We are able to change the political equation by talking. There is a political language that we need to bring to such conferences. And I just want to share this story by concluding. When we were in Kimwarere, this is one thing that the local community told us, that an organization like, before Hakimadini came to us here, we did not have this information. We were not organized. We did not know we are actually the people who can go to these government bodies and question what was, when you were saying, you have done this for us and all that. There is a place for civil society. But it is even better if we are able to get the conversation between community, civil society, governments, and these stakeholders speaking the same language. That's one thing that I would want to say. That is what we now need to focus, even in this conversation. I thank you, Crystal.
Thank you, Kimisop. And in another world, you know, the basic tenets of a feminist analysis is putting power at the center of analysis. And you've really spoken well to, you know, a gap between what happens in practice versus what happens theoretically. And at the center of that is a power play. It's a political one. And that, you know, comes in the way of organizing at a local level with communities, but also disrupts the idea of putting people at the center of our legal and policy frameworks and processes. I'll now pan to Francis Cairo, who's GFI's Africa Policy and Outreach Coordinator. And before working with GFI, he worked on anti-corruption, asset recovery, natural resource governance, and a whole, many other things. I met Francis in Mombasa, where we were working on a project, very interestingly using graffiti to pass on messages of public services. So it's really great to see him back in Nairobi and see him again after so many years. Francis, the same with Kimosop. I've explained who you are professionally. Would like to hear a little bit of who you are personally and who you are politically in terms of your philosophy. And while you do that, you, in conversation before this panel, you said most people in this room know what the policy frameworks are. We have a good understanding of the legal and policy frameworks. And what you really wanted to do is not bore us with, explaining them to us again, but really speaking to the gaps and what you think are ways that you can plug in those gaps. I'll pass on to you, Francis.
Yeah, thank you, Crystal. Good morning, everyone. Personally, I am a dad. In terms of my ideology, I am an Afro-optimist. I believe there's so much good in Africa that can be harnessed, and I believe that where we are as a continent is just the starting point, and things will get better. There is a wealth of knowledge in the continent. There's a world of optimism. There's a wealth of ideas on what we can do to move forward. And I therefore think, and I do not say this ignorantly, I say this having had experiences across. I know that our future is better. I am also, I believe in minimalism, and you can look that up if it's very new for you. One of the things as I discussed with Crystal is, you all know we have a constitution. You know about the mining acts. You know about the petroleum laws. You know the mosaic of laws we have that look at our land rights in Kenya. And I do not want to bore you with those details, but I think there are several things that I want to highlight. And I am a big fan of judge-made law. When we look at how the law is working in practice, those are the things that fascinate me the most. And those are some of the things I plan to highlight in about 5 minutes. One of the things that I want us to think about is that in 2012, we went through an extensive process of changing our land laws. So we came up with a new Land Act. We came up with new laws that look at the rights, public land, private land, and all that. But one of the things that we have not done is that if today you're holding a title to land, you're holding a title that only existed under all the repealed laws. We do not have new titles that have been printed and issued under the new land laws. And when we go out there, we are encouraging our people and telling them, you have land rights, you need a title and all that. And the question that we must ask ourselves is it legal to be using a title under the old repealed laws and to say that those titles guarantee us land rights, especially among communities? It's a question for us. One of the other things that we did is that if you look at Section 119 of the Mining Act, and you look at Section 119 of the Petroleum Act, those two sections are almost word for word. They look at mining activities under the mining law, and under the petroleum law, it looks at the publication of contracts. And those sections, they require the CS, the cabinet secretary, who is the equivalent of the minister in other jurisdictions, to do the following things. One is to have mechanisms in place for transparency and accountability. He is required to publish annual reports on the website. The CS in both laws, they are required to ensure that records relating to concessions of a land are published on the website. And the Mining Act is very clear. It requires the CES to make regulations available to ensure that there is transparency and accountability in place. And there's a question now here for us. Has this been done? Obviously no. Will it be done? Big question. Now that it has not been done, now that we have a law that requires the minister to publish these concessions, contracts, annual reports on the website, and it is not being done, what is it that we can do? Where do we then come in as civil society to ensure that these things are being done? Huge questions for us. One of the other gaps that I think we need to look at is, can the county government, I know we have spoken a lot about county governments, but can county governments help in enforcing mining laws? The judges have said no, they cannot. And now that we have that devolved level of government, what role then do they have to play if they are not in any way going to be involved in, not at least enforcement, but in the implementation of the mining laws? Because we are saying, for example, one of the things we want to do under the Community Land Act is ensure that counties have a stake in the management of community land. And we all know that currently most of the mining is happening in community land. If counties cannot be involved in any way in the implementation of these laws, then where are we heading as a country? And how can we remedy that? The other thing that I want us to think about is, should counties be involved at the point where concessions and prospecting licenses are being given? And there's a case that was filed in regards to the Mui Basin, the coal mining project in Kitui. And the judges said counties must be involved at the point of prospecting licenses being issued and concessions being given. But then there's that question of, what does involvement mean? Does calling the counties to a meeting at Kenya School of Government count as involvement? Because anyway, the license will be given whether or not the county objects or says yes. That was in the Fengsi mining case. The other thing that I want us to note is that the right of access to information, we all know Justice Majanja, that case, he said it can only be exercised by citizens. And therefore, this is where individuals become important. Because I know we all operate through very good structures, civil society organizations, international organizations, but it is clear that citizens themselves as individuals are the only people allowed under the law to exercise the right of access to information. And therefore, as we write the letters, as we request for information relating to concessions, let us remember that. And as I conclude, this is the most problematic one. As we rested because of COVID, as our courts were closed, you may have heard of this case that was filed by Rockland. Rockland is one of the biggest gemstones dealers somewhere in Taita Taveta. They filed a case and they wanted the following things. They wanted the payment of royalties under Section 183 of the Mining Act suspended. Number two, they wanted the prescription of mineral royalties under the Mining Act to be suspended until their case was heard and determined. Number three, they wanted the Community Development Agreement Regulations of 2017, and I had them mentioned here yesterday. They wanted them suspended until their case was heard and determined. In April 29 April 2020, the court agreed with them. And therefore, as we speak now, the payment of royalties under Section 183 has been suspended. The prescription of mineral royalties has been suspended. The regulations, the Community Development Agreement Regulations 2017 have been suspended. And if that is not problematic enough, When the Attorney General was served with papers in this case, they came to court but never filed any reply. And therefore, one of the reasons why rockland mining was given, the application was allowed, was because the application was unopposed. And therefore, today as we speak about empowering communities, as we speak about the prescription of mineral royalties, as we speak about the rights of communities to be to receive that 1% for purposes of community development, it has been suspended. I think that is space for us to think about what we could do, because the Attorney General, if they never replied to the interlocutory application, I am sure they will not reply to the substantive application. Thank you.
Wow, I'm really glad you remain an Afro-optimist in that space of work. I'm not so sure I would be able to, but I'm glad we have an Afro-optimist pushing the agenda. Francis has opened up a number of questions, opening up, questions around the devil is always in the details, and these sweeping statements that we make and what it actually means on the ground, and opening up questions around what it means when the Constitution of Kenya has is deeply rooted in tenets of public participation. What does that mean when our legislation and the actual detailing of our laws is removing that away from possibilities for citizens to access all sorts of things? I will now move to Bernard Ochieng, who is a public policy and governance practitioner. He's a community organizer and a social researcher. He's a program coordinator at Econews and is in charge of the Extractive's governance program. Bernard, like all the other two panelists, I've described who you are professionally. I would really like you to describe who you are personally and what your political views are or leanings are. And as you do that, we would really like to hear from you practically what the need for policy reform and governance in the Kenyan extractive sector is. Welcome.
Thank you very much. I don't know whether you'll allow me to stand there. So that I speak standing. Simply knows that when I speak sitting, I don't feel like I'm communicating. So I will stand here for those minutes that you allowed me to speak. My name is Bernard, as Chris has said, and I call myself a social democrat. That is probably philosophy that guides what I do every day. And what I would probably add there is that by the virtue of the organization I work in, which is a member of Haki Madini Coalition, we are also the chair of, the co-chair of the coalition, which is a movement that tries to bring together the policy space and the community and all the stakeholders together in this area of extractives work in Kenya. And also, above that, I always believe that communities have a voice, and these voices needs to be heard in the policy decisions and even political decisions that take place. So I was asked to speak about practical experiences, and I was told to be strict in Kenya. And because we sang the East African anthem, I think I can pick some examples from the East Africa, if I'm allowed. And let me remove this mask so that I confirm that I'm complete. Otherwise, I could be having a yellow tongue. And yesterday we were told that chemistry is witchcraft. So we know that extractive sector in Kenya is just coming up. It's not a boom, or it's not a very big sector as we speak currently. And because it's emerging from where I stand, I think there is a lot of opportunity in it. Even as it grows, we can start mitigating probably gaps and areas where IFFs could come in as this sector grows. Because the danger is that when it grows with IFFs entrenched, then we'll land where other corporates are. So status of mining in Kenya, we have various companies. And of course, there are only two companies that are significantly doing mining work in the country in terms of large-scale operations. And that is Base Titanium that operates in the in Kwale, which is an Australian-based mineral and sands producer. And they say their focus is Africa for that work. We also have another company in Kajiado. It's called Tata Chemicals Magadi, which is also incorporated in Mumbai, that is in India. And we have another one, it calls itself medium scale, not really large scale, and it's doing gold in Narok. It's called Kilima Pesa. This is also a gold plat subsidiary that is registered in London. And then we have Acacia Mining Company that we were told here yesterday is now changing from Acacia to Shanta Gold. It has been doing prospecting. And this is also a London-based company. Then we have Talo. Talo, we know Talo in Kajiado, that's also UK-based. And we have another one that probably most of us are not aware of, called Karebe Gold Mining, subsidiary of a company called Maris Group Limited, headquartered in the Republic of Mauritius. So these companies can, the way they're coming from outside to do business in Kenya can tell you some of the things that we're talking about, like tax havens and all that. And there are numerous small-scale and medium-scale operations are happening, and also artisanal mining that is basically illegal as we speak. So it means the currencies, the money that flows in those illegal businesses are illegal financial flows. Not because they like, of course they like it. They will tell you they could have formalized, but there are also policy gaps where they are not formalizing. I think we talked about that yesterday. The economy survey for 2020 in this country indicated that mineral resource and oil sector contribution is minimal. In 2015, the income that was received from this sector is US dollar 239 billion. But 2018 and 19, it went up. In 2018, it was US dollar 308 million. 2009, it went down again. So again, it's fluctuating that way. But in 2019, out of the 29 billion that was realized in terms of income from the extractive sector, the mining sector rather, 67.5% of that was from base titanium. And then 17% was from soda ash, that is now Tata in Magadi. Then gold and others contributed the rest. Gold was for 4.8% and others contributed the rest. So that tells us that the major mining companies in this country is base titanium and Tata Chemicals. So what are some of the ways IFFs occur in this mineral in my view? Corruption is big through bribery in awarding of the licenses, and this one we were told here yesterday. And also illegal transfer of samples. You know, when companies are doing exploration or prospecting, they're not supposed to sell. But we have seen where companies are selling the samples that they're not supposed to sell, and that's also illegal. Then we have illegal exploitation and licensed mining, and this has happened severally in Migori County, where Chinese companies go there and start digging the ground without any licensing. Somebody whispered in my ears yesterday that that's what costed the previous PS, the issue of illegal mining, particularly with those big companies. Then there is also misreporting of volumes that are gotten by these companies, which also I link that to tax evasion, because when it is misreported, then it means the calculation of tax will be affected downwards. And sometimes also reporting losses, like Tata Chemicals has been reporting losses since way back below 2002. They have been reporting losses, and therefore they cannot pay tax. So they have been deferring tax. Even last year they deferred their tax since 2002. So there is huge tax arrears that the government should collect from Tata, but they can't collect because the company is reporting losses. Then base titanium taxable income in 2019 was 20.9 billion. They paid corporate income tax of 1.7 billion. That is rated at 27.4%. Probably we know that the law in Kenya, Income Tax Act, says 30%. So you wonder how we are calculating their 27.4%. Then in terms of royalties, they paid at 6.9%. The royalties regulations, which are supposed to be effective, talks about 10% for the type of minerals that they're mining. So those are negotiated royalties. And because the agreement is not accessible, we may not know. But if we use the law as the basis, then we ask why are they paying 6.9% instead of 10%. And even in the previous year, they paid 6.8% in royalties instead of 10%. Now, if we go to total chemicals, in 2019, they reported sales of 6.7 billion, and in 2018, 7.3 billion. And they reported loss in both the years, and therefore they did not pay corporate income tax. They deferred, and as I've said, they have been deferring for a very long time. And there is a lot of money that is due, which is demanded by the Kenya Revenue Authority. Even the county government is demanding arrears in land rates amounting to 17.45 billion that they have not paid. So that's just a brief picture of what is happening. And the royalty rates in 2019, for example, was 3.4%. The royalties regulation says 5%. So we can see where the divisions are in terms of the practice, how the companies have been given a leeway to do things probably they really want. So some of the challenges that I will highlight quickly as I conclude is that looking at the policy space governing extractive sector, there is a problem of data. And this has been used by the corporates to actually negotiate their way out, because once they come and do exploration using their own data, they are going to charge that. Yeah. And they're going to charge it as a cost that they incurred preparing to mine, and that's when it's being charged, so they don't pay tax until they cover the cost, even sometimes for development. Corruption has been highlighted as well, particularly in licensing and contracting, which is another key thing that is facilitating IFFs in the sector. Lack of transparency in extractive sector, particularly contract confidentiality, and we have talked about that. Like, we cannot see the contract. The law is saying that 119, there should be transparency, but it's not there. Like, if I ask any person in the room to get the PAC or production sharing contract for Tano, you can't get it. Though the law says that it should be a public document. So lack of political will to share those documents, and then also compliance issues. And then the last thing is benefit sharing, and the whole question of revenue management. And when we talk about royalties, that touches on the benefit sharing. We lack legal mechanism. Of course, we are almost having consensus that we have enough policies, but we don't have any regulation governing the sharing of royalties or the sharing of the benefit that accrue from mining. So that's a still a policy gap that exists. I will give recommendations probably there.
Thank you, Bernard, for, oh, Cyprian wants to give a clap. Actually, let's give a clap for everyone. I'll also ask Cyprian how many more minutes we have. Just do a time check, just so we are not running into the next sessions. 7 minutes. Cyprian, 7 minutes. With such a wonderful panel. Okay, we'll open up for a few questions. It's been an interesting coming together of what practically happens on the ground, what the law and policy framework says, and how there's such a huge divide between the two. I'll open up for a couple of questions. Cyprian gives us 7 minutes, so I'll open up for 3 questions, and then we'll do a final round with panelists to give us a very short, like if there's one burning recommendation they would give in the form of a tweet. So 1-2 sentences. Yeah, questions? Are you just floored by the level of detail? I see one question. Is there, and 2? We'll start with the lady at the back. Please introduce yourself.
Thank you. I'm Monica, AJEC Africa, and also Association of Women in Mining in Africa. I'd want to I don't know if it's a question or comment on the role of the county government as outlined in the mining law. And having been involved a lot in the drafting from the beginning, I've really gone through the notions of what he highlighted. And I think one part that the county was left to administer first was the issue of construction and development minerals. That's the sand harvesting, the stones like Mazeras, etc. That was agreed to be left first to the county government, to the purview of the county government. Another issue that you brought up that is, maybe I want to hear your opinion as well, because it's a huge bone of contention for the private sector when it comes also to the role of county and consent giving, Section 34 of the law, where it comes to consent to give prospecting, mining, prospecting licenses. And the way the law is couched right now is there has to be explicit consent even for prospecting activities. And if you're applying for a mining prospecting license, not only do you have a community consent, but you must also demonstrate county consent before you're given that prospecting license from the Ministry of Mining. Now that has been a big issue by investors because they say it's becoming very cumbersome and onerous. Before you get community to give you consent and the county government to give you consent, according to the investors, that is actually making Kenya not attractive for investment because the entry, they see it as a barrier to entry. Yet on one side, from this perspective, you see it as what's the level of involvement, Another issue has been when you talk about what is the role of the county government, when they've been left to some extent to assist in implementation and, of companies, they have actually increased the cost of doing business. So they look at it from leveraging more royalties. And as we know, the administration of minerals as the part of the national government. So for their role, every time you give them an opportunity, they want to charge further. So they want to charge cess, so the investor pays cess at county level, but you're also paying royalty to the national government. And that has been another bone of contention. At what point and what should really be the role of the county in administration of these minerals? Because they've been involved at giving consent, they will be allowed to give a license, a business permit at county level. When the operation is, when the company is in operation, what else should we allow the county to do, where they will not deter or in any way, affect the investor in operation by charging and levying further costs, because unfortunately, that has been the way they viewed their role in operating companies. So I'd want to hear from you, is that enough? Or what else do you think at that point counties should do in productive mines? Yeah.
Thank you. We have one question towards the front.
Thank you very much, everyone. I think very, very excellent panel. I think my question is probably to Vincent. I think when you listen to some of the issues that Francis has brought up and Bernard as well, very practical challenges we're facing. I really like the theoretical framework provided, the axis between politics and processes, I think which you focus on a lot. And then I think the politics and power is being used to frustrate the spirit and the intent of the law. And you can see all the way into government, the Attorney General's office, and I think the examples you gave are very sobering. But I think the question to you is, so what? What can organizations do? How can we act politically without being politicians? So we don't want to be politicians, but how do we act politically? How do we apply feminist principles or looking at the lens of power to actually address some of these challenges so that we're not just kind of talking through them, but we're moving from the conversations of this theoretical framework and practical to actually practical things that organizations that have an interest in making sure that the extractive industry actually works, applying either the lenses of power, the feminist principles, or acting politically in a way that moves things. Thank you.
We have space for one more? Yes.
Thank you. My question goes directly to Francis Cairo on the issue of royalties. How can community differentiate between royalties and corporate social responsibilities. Because sometimes defining community is also an issue. Because in a community, you can find some cartel calling the same community. So how can a community differentiate between corporate social responsibility and the royalties? Thank you.
Thank you. I saw Vincent grab his microphone and really itching to respond to the second question. So I'll pass on to you in 2 minutes before you give your recommendations.
Great. I didn't get your name, sir. And John. John, they have done 5 bills in Parliament without being a member of Parliament. And the reason is that there is an art and the language of power. That are one of the things I appreciated in this space, in civil society, we need to have. For example, my colleague Bernard and the team, at the moment in the Kenyan space, because of COVID-19 and the economy slowing down, the first conversation in the political space is how do we recover, how do we generate employment, and how do we get our economy back. So if you have the conversation of accountability, the issues my brother has raised, the politicians don't have time for you. So one of the things I tell civil society organizations is we need to learn this art and the language of power. And what is the language of power? In Kimwarer, a philosopher where I went to the ground, one of the ways that I have seen the language and the art of power come in is in engendering the conversation. There is a language that feminists or I hardly use that terminology, but today let me use that. When you engender the conversation, when mothers speak, for example, in the village, like I'll tell you, the company in Kimwarer, before the community knew, was owned by the former member of parliament, who was a minister, who was very powerful in government. So on the other side of the field, they are praising, singing to him that, oh, Meshimua, you know, those kind of talk to get them to power. But when the veneer was lifted and they realized that the very people who are supposed to be advancing their rights are the very people who are, who are suppressing them, in the area and the language that the language that is used there is the language of the curse. And it is not in policy. That's why I painted that issue that at times in this space we do policy process, but we forget where power and politics. I'll give another example. When the Kenya Human Rights Commission was doing the advocacy work when there was human rights violations by Del Monte, I'm telling you, my brother, they went petitions, you know, laws, legislation, you know, all the things that you have on the script. But until one time, we came up with a terminology called touching the soft belly of the beast. Now, what was the soft belly of the beast for Del Monte? It was the company where it was the supermarkets in Italy where they were selling the juices. And when we looked at they looked at the contracts where the supermarkets in Italy were selling, they had signed an agreement that we will not be selling products here that have been used or its production have violated human rights because of the European standards. When that was raised to the company and they said from now tomorrow morning, no more products from Del Monte, what happened? They changed, everything changed until even the products were available in the market. So for me, my quick recommendation, I just give those 2 examples, engendering the conversation, getting to know what is the soft belly of there's a company, I think my brothers mentioned, who we need to get that information. The other thing, finally, number 3, is that the conversation, at times, we need to follow the conversation through. I see in civil society or the organization, we normally look at the Mining Act, the players, but look, for example, if you're a Kenyan, the role of the provincial administration. So we should not just look at, we need to look at the entire scope so that our engagement is not only, for example, in the energy or in the mining sector. You have a provincial administration, which is in the security-related engagement, but they have major bearings in certain space. So a holistic conversation. We can have a one-on-one, I can give further details. I was trying to summarize as much as possible because Crystal has 2 minutes. and I am a man under authority.
Thank you, Vincent, and thank you for giving us your 3 recommendations. I'll pass on to Francis, who's got very specific questions directed at him, and also to give his recommendation or recommendations. I guess the more the merrier, but in a very short formulation.
Thank you. I think with counties, this is where the problem is. Because counties see their involvement first from how much can we get out of this deal. And it is very short-term planning. When base titanium started mining in Kwale, what the county government first did was start impounding the trucks for purposes of payment of cess. So a whole truck that is carrying a whole big load of ilmenite was asked to pay 200 or 300 for it to pass through Kwale County to go and deliver ilmenite so that it can be exported. And as long as Kwale County could get that money, they were happy because at least they were now using their power in a way they could be felt. And I think this is where the confusion is. Counties, how can they, for example, help on matters of local content? There's so much counties can do. How can counties, for example, if they were to focus on ensuring that, for example, there is safety in artisanal mining, counties can do that. Counties, for example, if you look at the beneficiation of minerals locally, counties can help. I was shocked to pass through Murang'a County the other day and to realize that they have an area that they would want to lease to companies that want to do any local value addition to any of the stuff that comes out of the county. And I think this is what ought to be happening. Yesterday we spoke about jewelry, incentivizing jewelry makers to come and do those things locally. Counties can be able to do that. So their involvement doesn't have to be at the point of wielding power. It doesn't have to be at the point of levying charges. There's so much they can do to support especially citizens to ensure that citizens can benefit out of the work that is going on in the counties. In addition, there was a question in regards to royalties and CSR. CSR, companies engage in CSR so that they can reduce their tax burden. Because once they can be able to prove that they use some money for CSR to build roads, to build a school, to give water, they get tax deductions because of doing that. So I'd say one of the biggest differences between royalties and CSR is that royalties are there in the law. It is a legal obligation to share with communities. CSR, we do it when we can, we do it when we want. And unfortunately, because they are wise enough and they employ some of us from civil society, like Base Titanium, they know what communities love. Communities love water tanks. Communities love roads. The chief needs a good office, and they will do that as CSR. And once they have done that, the mouths of those that could speak on behalf of the communities are suddenly too full to speak. Now, we are left as civil society complaining to say, oh, the community is not benefiting. And unfortunately, I mentioned that as it is now, the law on community development agreements has been suspended. It's quite serious. And I think that is our beginning point. I think in making my recommendations is, as we have our conversations with the counties, let us help them to move away from that mind of let us impound trucks and levy cess. Migori County was recently hit with a court order to pay 48 million Kenya shillings for impounding a truck because it had mineral ore inside. You can imagine how much that money is lost simply because the county did something outside the law. So as we have conversations with the counties, let us encourage them to move away from thinking about the bottom line of how much money can we bring in through cess and through impounding trucks, and move on to a more qualitative conversation of how can we help communities to, for example, start local value addition. How can we help communities to do better in terms of local content? Secondly, I think as civil society, when, for example, Rockland is arguing in court about whether they ought to pay royalties, I think we ought to be there as civil society. We ought to add our voice in public interest litigation and, for example, bring in the other perspective of what do royalties mean for communities? What is the importance of ensuring that communities can benefit out of the investments that happen in their communities? In addition to that, I know that Section 119 of the Mining Act requires the minister to publish regulations. I think previously as civil society, we have blazed the trail by developing what we can call working drafts, by having regulations that have bare minimums that we can use for purposes of engaging, for example, with the ministry, because the expression of our joint minds can be contained in the draft regulations that we, like a civil society, can develop. And then when we engage with the Ministry of Mining, we can have a benchmark on which we can be able to compare. So that even when the minister decides to publish his own regulations, we can have our own reflection point to say, this is not contained, this is not well phrased, this will not work for communities, and that's it. Thank you.
Thank you, Francis. Bernard, I'm getting eyes of time, so I'm really sorry. I have to ask you to please keep it brief. There was a question directed to you, and as you answer that, I hope you can weave in your recommendations for this session.
Thank you. I think the question was on consent, and consent by county government and the community. This was one of the best things that communities applauded, having the power to give consent for the mining companies to extract from their land. Though it has been misused, particularly the politicians have used it to incite communities to make it very difficult for access to their land to be made possible. So I know there is a discussion that is ongoing to start the review process, and the review is to make consent only be asked at the time of asking for the mineral right, not exploration or prospecting, because it has made it very difficult. And also it said that when exploration is very intrusive, that to mean that it will interfere a lot with the people, then the consent will be sought from the communities or the owners of the land. So it's a discussion that investors have been making noise about, that it's really hindering investment. But we know that politicians, particularly the county representatives, the MCS, have really used it to incite community to make it very difficult for operations to be undertaken. Now, one of my recommendations is that I think as we engage with these extractive companies, particularly the large scale, I think one of the soft belly that Vincent was highlighting is their beneficial ownership. And normally these people are not, particularly for the multinationals that are coming to invest in a particular country from a different country, these beneficial owners may not even be in the country. So I think in our engagement, we need to start bringing them on board or probably finding out where they are so that they can also be part of these conversations. Because sometimes if they're getting threat from where the company is operating, then I think we can probably get some political ear to deal with some concerns that are being raised. Then another thing is on tax incentives, and I highlighted some of them in the presentation. I think we need to review, because there are some unnecessary tax incentives that are being given to this company. Why would a new company be given 10 years a tax holiday period for them to establish and set up themselves before they start paying the tax? I think we need to go towards reviewing some of those incentives so that they make sense, particularly when we talk about local resource mobilizations for development. And then finally, I think the extractive sector in Kenya require monitoring of IFFs that are happening in there. I've tried to look out for any particular report looking into the IFFs in the sector, and I wasn't able to see any. So I think we need to also focus on integrating that into the sector. Thank you.
Thank you, Bernard. Thank you, everyone. I'll ask for a round of applause. A nice one, warm.